Now, the main principle of the Brussels I regime and convention regulation, first the 2001 regulation, now there is a new version, as you may know, of December 2012, but the system has, in its main traits, always remained the same. The founding principle is that the court of the domicile of the defendant is competent. Domicile of the defendant. Now, the initial Brussels Convention contained an Article 6, which simply said that more than one defendant can be sued in the court of the domicile of one of them. That was it. So you can sue a plurality of defendants, each of them having their domicile, or for businesses their seat of commercial establishment in whatever member state, but you can sue them all together in the forum of the domicile of one of them. Final stop. You see the problem. The condition that these defendants needed to be sued on the basis of the same cause of action, and the need there to be a link between these defendants to a single substantive action had not been expressed. So the textual interpretation would have manifestly led to an overbroad interpretation, because it in fact would have allowed for unrelated defendants to sue them in a single action. Now you say, why would they do that? Well, not too quick. You may, for instance, as a business, and that was here the problem, a distribution contract with 5 different undertakings for different countries or for different territorial resorts. You simply pick one and you say, well, these other contracts are certainly different, but they're similar. So I sue them all 5 in the court of the domicile or the establishment of one of the defendants. But there is no strict legal link. There may be similarity, but it's not an identical litigation. So it was the Court of Justice which, on the basis of a teleological interpretation of that provision, reduced the scope of application of it. Also holding that since Article 6 was a derogation clause vis-à-vis the general article on the competence of principle of the domicile, of the court of the domicile of the defendant, the court said this Article 6, being a derogation from the general principle, has to be interpreted strictly. The objective of that article was to have substantively related litigation brought before a single court. That makes sense. And only to that limited teleological sense can you derogate from the general principle. So it's an example where teleological interpretation leads to a reductionist reading and not to an expansive reading. So what I'm arguing here is that one could not go too quick by equating teleological interpretation with expansive interpretation, judicial activism, and a court engaging in competence creep or overstepping the boundaries of its jurisdiction. Consistent interpretation. Here, the Court of Justice is not working in isolation. The Court of Justice is related to the legal orders surrounding it. First and foremost, public international law. And without going into any details, it would lead us too far. The most frequent use in the judicial process of seeing to it that the law is observed in the interpretation and application of the treaties on which the European Union is founded, the law includes public international law by which the European Union is bound. All that law to which the Union is bound will be used as a reference standard for consistent interpretation. That is general, even the treaty law. Any time that a court can interpret union law, surely the whole of secondary union law, but even primary law. Primary law is a small nuance to which I come in a minute. The court will interpret consistently with international law. But consistent interpretation is always subject to an important proviso. It will not go that far that a court would interpret the text contra legem. That is, provisions of primary law, in case of doubt, will be interpreted consistently with international law, but not to the point of contradicting the clear tenor of these primary law instruments. I give you quickly two examples. The first one is the Cadi saga. You know what Cadi is? Cadi is suspected person suspected to be linked to financing streams of Al-Qaeda and Osama bin Laden. He is put on the list, and this in implementation of the United Nations Security Council resolution, having decided smart sanctions, as it is called, against a list of named individuals and organizations, one of whom is Mr. Cadi, and the European Union blindly takes over the list without further ado and says, I must do so because if I don't, I'm breaching international law and I'm helping my member states to breach international law, and as members of the United Nations, they're bound as such by the resolutions of the Security Council. The court says, well, this may all be true, that the member states and indirectly the European Union are bound by these resolutions. I do not quarrel with that. But the United Nations has no power to shake the constitutional foundations of the European Union and by extension of any of the states members of the United Nations. So in Cadi 1, the court drew this as a bottom line in this relationship between public international law and the EU legal order. The constitutional foundations of the European Union could not be set aside. That is, the Council or the Commission, depending on who is taking the act of implementation, needed to state the reasons, and now the Cadi 2 judgment will be delivered on the 18th of July, so I can't reveal you the content yet, but I can tell you that there the court is now to pronounce on the intensity of substantive judicial review of the decision to list Mr. Cadi in the EU law instrument blocking his assets, and what type of evidence should be adduced, and what is the intensity of judicial review to be carried out by the General Court or the Court of Justice. So what you see here is the court will interpret and apply in tune with international law. A case where this was done is the Bosphorus case, the 1990s, where the court interprets the regulation imposing sanctions on all commerce with former Yugoslavia. The court interprets this in line with the proper interpretation of a resolution of the Security Council. Consistent interpretation was perfectly possible. In Cadi you see the limit. There the court says the public international law system, which should itself uphold fundamental rights worldwide, cannot expect from its member states and for the European Union acting for the 28 member states to somehow abandon the constitutional foundations on which that legal order is being based. I promise you a second example, which is a bit in the same sphere. The court will, exercising its jurisdiction on opinions to be given on a projected international agreement to be concluded by the European Union with third states, the court will not accept that in such an agreement, that is, an agreement to which the Union will be bound once the Union concludes the agreement, that such an agreement would weaken the position, the constitutional position of the Court of Justice to say what the law is in the interpretation and application of the treaties on which the Union is founded. I'm referring here to Opinion 1/09 on the projected court system for the unified patent. I mean not the agreement which the member states of the Union, that is 25 of them, by way of enhanced cooperation, now recently concluded. It was just published, but the previous version, where the project related to a court system which would also have included third states. There the court said no, because this international court takes over jurisdiction from the national courts, also with a view to applying union law. Now the national courts refer to the Court of Justice in the judicial dialogue, which that international court, on the basis of the Union Treaty, cannot do. This weakens the system of saying the law in the interpretation and application of the treaties. Because if the national courts are no longer empowered to deal with that litigation, but see their normal jurisdiction to be passed on to a newly created international court, it also means that the Court of Justice will no longer be in a position on these matters to interact with these national courts. So the court said no for that reason and for that reason alone. And that is why the member states involved in the unified patent, which means all member states except Italy and Spain, because of the language regime saga, they now concluded among themselves a court system. And that court system has, legally speaking, the same status as the Benelux court, common to the 3 Benelux countries. And that court is seen as a court of a member state. So the uniform patent court system is in the same way as the Benelux court, now organized as a court common to all the 25, 26, when Croatia now is in, participating member states. And therefore, they are bound in the same way as national courts to interact with the Court of Justice. So you see, the Court of Justice, in interpreting union law, will go as far as it can to bring that interpretation in tune with the broader world environment to which the Union is bound, but subject to the no passerán when it comes to upholding the constitutional foundations, of which, first and foremost, the upholding of the rule of law is the essence of the court's case law. In relation to the national constitutional orders, of which I spoke you, and I'll end with that because otherwise we will not have the time to answer some questions, and I saw that there are already some questions, so I give you the floor immediately. Here I would simply refer to the fact that in finding the law, and it's a good point to conclude actually, the court is not operating in a vacuum. The court is handing down now more than 600 decisions a year. I'm speaking of the Court of Justice, that is not a general court, not a civil service tribunal. More than 600 decisions a year. More than 400 of these decisions are handed down upon a request for a preliminary ruling coming from a national court. That is extremely relevant. Why? The national court is not just asking an informative question. That is, what does mean this and so and so. No, the National Court sets out a judicial decision, putting up a framework, reasoning aspects of union law, and putting all of that to the attention of the Court of Justice. Saying maybe how national law reacts to a problem, and then inquiring what the input in the case of union law is. In other words, the court really is in a dialogue mode with the national courts. The national court setting the stage for a reference, for a preliminary ruling, has a serious impact on the content of the ruling. It's something which I did not realize, I must say, until being in the deliberation room of the court, which is now my daily working place. Because indeed, even during the deliberations, we will look very precisely at what the problem of the National Court is. We will read and reread the order for reference to understand the facts, the national law aspects, why the question was asked, what the real problem is, why the doubt occurred with the National Court, and all of that will be taken in. The member states, having been entitled, and some of them also really participating in the procedure, they will have reacted to that order for reference, also that. The content of the judicial debate taking place in the Court of Justice is largely conditioned on the content of the reference for the preliminary ruling, and on that basis the court will proceed. Now, if you see how the court thereby uses comparative law as a method of informing the court's judgment, that's also an extremely important legitimating factor for the court's pronouncements, which are judicial decisions, but having a huge political, social, ethical, cultural, economic, and other types of impact. And the court is aware of it. First of all, it's a national court asking us to rule and setting the stage. And second, the Court of Justice will be informed about comparative law aspects from national law. And this is needed because very often the text of the instruments of union law does not suffice to come in an unequivocal manner to the outcome of the case. You all know cases as Omega and Saint-Wittgenstein, cases where the national courts explained to us in the Omega case what the requirements were of protection of human dignity in Germany, the court having taken that discourse into its judgment, saying, all right, this may not be the sort of understanding, very exigent understanding of human dignity in other member states, but that is a genuine concern for Germany, which is well argued and acceptable. It has certainly no protectionist afterthoughts or pretexting. Therefore, we validate this. And the court, as you know, validated on the basis of the German understanding of human dignity what constituted an obstacle to the free movement of laser games in play arcades. Saint-Wittgenstein, an obstacle to free movement of persons in that a part of the name Ilonka Fürstin von Saint-Wittgenstein, a part of the name under which that person was known in Germany, because in German law, as you know, the nobility title is part of the name. She moved back to her native Austria, and there they said, Fürstin von cross out, Ilonka Saint-Wittgenstein. She said, well, but that's another name, people will doubt about my identity. And the court said, well, yes, this may be to some extent an impediment to your exercising free movement, but for Austria, the fundamental equality between all people, irrespective of their status, nobility or otherwise, is so fundamental to the republican form of government that we validate this as a legitimate concern for the constitutional order in Austria. So you see, value pluralism is being accommodated by the Court of Justice because in saying the law, the court is aware of the fact that union law is to be inserted and operationalized in national legal systems whose essential features are worthy of respect. That is, as you all know, Article 4, second paragraph of the Treaty on European Union, by which the Union respects the national identity of the member states. Equally important is the use made by the court of the constitutional traditions common to the member states. There I'm referring you to our developing case law on same-sex partnerships, where the court has taken good note of the fact that ever more member states are now accepting same-sex marriages, registered partnerships in which the partners stand to one another as far as rights and obligations go in a very similar fashion as spouses. And the court has taken all that in its case law. I'm referring to the recent, relatively recent cases, 2008 Maruco, 2011 Römer, 2012 Dietrich, and there is more to come. So you see that the court there stays in tune with the developments in the, I would say, the adjacent parcels of land, that is the adjacent legal orders with which the court together forms a mosaic. I think, without going any further into the charter, because that is still a bit more specific, if you have questions on that, I shall answer them. But I think all of this should leave you with the following impression, I hope. First of all, that the court sticks from its standpoint very strictly to its central mission statement, that is to see to it that the law is observed in the interpretation and application of the treaties. That is not an empty sentence. It is the foundational sentence for the daily work of the court. The court does this a bit in line with the Vienna Convention on the Law of Treaties, Article 31, even today, in terms of making the best possible sense of the usual meaning of the wording of texts, of the context, of their telos, of the objectives. All of this in light of general principles, equal treatment, proportionality, consistently with public international law, but without admitting that public international law impinges upon the constitutional foundations of the Union. Just like the court suggests that no state around the world should accept this. And finally, in constant dialogue with national courts, providing elements of national law which the court either respects or makes use of in integrating them in its own interpretation of union law. Yes, there is a political, societal and other impact, but the process pursued remains a strictly judicial process. Thank you. So I have the time, so I hope you have still some time for questions. Yes. I'm starting maybe from here till there, so you will all come, so starting here and then we go on like this.
Working already, okay. Thank you very much for a wonderful lecture. It was really a delight.
Pleasure.
My name is Anna Kocharov. I am here a researcher at the EUI. I'm finishing my PhD now. It was particularly comforting to know that there is no judicial activism, and you have started by pointing out that all the political actors who enact legislation have their reasons for doing so, that every part of every law should have, we should presume that there is some reason for it and some objective that the legislator wanted to achieve. Not only so for secondary acts, but even more so perhaps for the treaties, which, as you mentioned, contain objectives. for union action, both broader objectives and objectives for particular policies. Well, my concern is with a little bit different narrative of the role of the legislator, and in particular what happens in situations such as the case that you cited on the qualification directive, where objectively in the European Parliament, for example, members of Parliament cannot agree on the wording, and they insert either opposing wording or perhaps to make may clauses, the famous may clauses that are inserted in many, for example, immigration directives, that allow member states to do something, but their added value is really very interesting. Actually, my question concerns exactly that. Is my understanding correct that you do not see the role of the court as filling in these gaps left by the legislator? Do you completely deny that, or are you just saying that the court does it in light of a broader context and general principles on coherence? Thank you.
Well, in fact, your question relates to the legal status of gaps, and it's an essential question. Some gaps are intended. Those the court may not fill. If the legislature makes it very clear that the gap is meant to be there, and has maybe even justified why it is there, it's quite clear that the court must respect that. I return to my case of Sturgeon and Nelson and TUI Travel, these two cases. 2009, 2012, if you want to look them up on our website. In those two cases, there was a gap in that no compensation, no lump sum compensation was provided for those passengers whose flight was heavily delayed. The court, however, analyzing the preparatory works, has concluded that the gap had not been intended, that it was maybe an oversight, but it was not the intention, and the court says so. It cannot be presumed, the court says, that it was the intention of the legislator, positive choice of the legislator, to deal in an unequal fashion with two situations which, from the perspective on which the legislator itself had been placing itself, are totally similar. And hence, in order to interpret the text in compliance with, consistently with the principle of equal treatment, the gap will be filled. But the court, like such a case shows, is very well aware that that is really at the limit of what you can do as a court. And the court goes, therefore, through quite a bit of effort, and you can read it in the judgment, to justify and explain why the court does so. And I shall not conceal from you that a number of case notes on that judgment remain critical. A number are also expressly approving, but I mean, a whole range remain critical, because they say, well, it's a very nice attempt to justify why they did it, but it remains expressly contrary to the text. The text is only providing for a lump sum in favor of the stranded passengers after a cancelled flight. That is not the same as a heavily delayed flight. This flies in the face of the text, and therefore the court should not have engaged in that sort of a gap filling. So I only give you this as a more precise answer to tell you that the court will look into the preparatory works. The court can, of course, not examine what individual members of parliament might have thought or wanted. So it's always what is the outcome of the process. So if there was, for instance, an initial proposal from the Commission, and after a vote in the parliament that proposal got amended, then it will be very important that the court make sure that this amendment is also reflected in the interpretation of the final act, and that the court would not, for instance, blindly accept an argument of the Commission Commission proposing an interpretation of the text which again is as close as possible to its initial proposal. No, there the court will say, listen, there have been amendments either in the Parliament and in the Council, or in the Council or in both, and the end process is different, or the end product better is different from the initial proposal. That has to be taken into account. So it's really in that context that we operate this gap filling. But gap filling is really a rather also for the court a delicate operation which the court engages in only with big caution. Yeah. It's one go from right to left.
Yeah, thanks a lot. I would also like to start by thanking you for this stimulating talk. My question concerns the remarks you actually ended with, rather the process of interpretation and who are the actors, who actually engages in this process. I think if you look at the court proceedings, especially in grand chamber cases, for example, there are really many actors who actually do the same task than the court does, interpreting, giving meaning to the text.
Absolutely.
The Commission, the European Parliament, the member states. And my question would be actually how to conceptualize in the European setting those many voices that you have in the court. How to conceptualize them as a judge? Like what do you do with a Commission arguing for a certain meaning, member states arguing for a certain meaning, and how to conceptualize them as the constitutional theorist or a constitutional lawyer. And I find those theories, for example, in the United States, very tempting and interesting for the EU, like popular constitutionalism, the idea that there are many voices and not only a court speaking and interpreting. But my feeling is rather that the ECJ understands itself rather as a monopolist, rather maybe as a monopolist in the sense of the Bundesverfassungsgericht, for example. So one actor giving meaning to the norms. And I think you see it also in cases like Ockerberg Franz, for example, where there were many voices really saying something different than the court did. So that would be really very interesting how you see it as a judge and as a constitutional lawyer. Thanks a lot.
Yeah, also that is an extremely good question. It is true that the court, like the Bundesverfassungsgericht, where I was on a visit, by the way, last Monday, so we have very regular contacts between the Bundesverfassungsgericht and our court, which is sometimes little known to the outside world, who think that the two courts are almost on no speaking terms. That is absolutely wrong, of course. There was an extremely interesting seminar in Karlsruhe hosted by the Bundesverfassungsgericht where we in fact also touched upon these questions. And much to the credit of the Bundesverfassungsgericht, I can tell you that the Court of Justice is being perceived by the German legal order as the gesetzlicher Richter of European Union law. What most people tend to forget is that the Bundesverfassungsgericht is one of the very best allies of the Court of Justice of the European Union, in that it considers that if a Supreme Court in Germany, and you know there are more than one in Germany according to the subject matter, if such a Supreme Court, Bundesgerichtshof, Bundesfinanzhof, Bundesarbeitsgericht, etc., Bundesverwaltungsgericht, if they're not referring a matter of interpretation of union law to our court, then they're not only breaching the third paragraph of Article 267 of the Treaty on the Functioning of the European Union, but under vested case law of the Bundesverfassungsgericht, they're also breaching Article 101 of the Grundgesetz on the lawful judge, and the lawful judge within the meaning of the German Constitution of European Union law is the Court of Justice. So that is a very important point. So the fact that the Court of Justice has the last word on interpreting in a unitary fashion for the whole of the European Union, union law, is actually unquestioned. Because the European Union is united in diversity. But it means that the degree of diversity which is compatible with the unity of union law is a matter of interpretation. And that is ultimately for the Court of Justice to decide. Like Omega Spielhalle, I've been sitting in that case 2004. It has been the Court of Justice saying union law perfectly tolerates value diversity here. Yes, this is to some extent an impediment to free movement, but it is clearly justified by the public interest in Germany, mandatory requirement of the public interest, proportionately pursued, and this can perfectly coexist with the internal market. Idem dito for Wittgenstein vis-à-vis the Austrian republican form of government and the fundamental equality between all people. So in that sense, I think the monopoly of interpretation of the code is inherent in having a common legal order. And it goes back to Van Gentenloos, to Costa NL, so these 50 years, where in fact the private parties have been put center stage. That is the big difference between the EU legal order and public international law in general. So the fact that right from day one of the legal order, private parties can draw rights and also derive obligations from union law, and they can enforce them before the national courts. Once that is the case, inevitably these national courts will be in a position to need to know what the unitary interpretation of that law is. So I think that is not so much criticized as such. Now, if you go on, and I knew these questions would come, so that's why I had not in the talk to go further on the Charter. If you go on with Åkerberg, Franzen and Meloni, but especially Åkerberg, Franzen, which you mentioned, there the Court of Justice had to interpret the provision of the first paragraph of Article 51 of the Charter. That is that the Charter is only applicable to the member states when they are implementing union law. Who speaks German here? Well, you should not tell it. In German it says ausschließlich bei der Durchführung des Unionsrechts. Ausschließlich. Uniquement in French. Uitsluitend for the Dutch speakers. So in all these languages a restrictive wording. So then the whole question is, what is Durchführung des Unionsrechts? Implementing union law. All the member states, having made remarks there, as you say, they all interpret union law. That's normal that they all interpret union law. Like any lawyer participating in a litigation also in national courts will present his or her interpretation on the law on behalf of the party interest. The same is in the pluralism of the united in diversity. It's part of the diversity aspect. Everyone gives his or her understanding of union law. But then you need a court where all these legal cultures somehow are being represented. That's the reason why the court has all these members in order to represent all these shades and sensitivities of national legal systems. All of this comes to bear in what is a unitary and final judgment, without which, very functionally speaking, the union cannot operate as a single legal order. There's no more to it. It's not a matter that the court knows better or something, absolutely not. Sometimes our deliberations are very difficult because the law is difficult. But you simply functionally need someone who says the law in final. That is the same what Chief Justice Marshall already said in McCulloch versus Maryland, 1824, in the United States Supreme Court. It's the same for the European Union. Now, how to handle these matters? The court is an independent court. In Åkerberg-Franzen, Sweden provided that for qualified forms of tax fraud, you could have next to the fiscal penalty, that is a serious upgrading of your tax liability because you had frauded. If this fraud was somehow falsehood in writing, in accounting, organized fraud, you could also be criminally prosecuted. And Mr. Åkerberg-Franzen, who was charged with qualified tax fraud in the income tax, in the value-added tax, and in the employer's contribution to the social security system, he had been heavily fined at the fiscal level and was now being prosecuted in a criminal court. And there he says, stop, ne bis in idem. I have already been sanctioned by all these fiscal sanctions, so there should not be this criminal prosecution and possibly fine or even imprisonment coming on top of that. So the Swedish court asks to interpret Article 50 of the Charter. But the first question was, is this criminal law procedure covered by ausschließlich bei der Durchführung des Unionsrechts? Only when they're implementing union law. The member states and the Commission also said, well, the only thing which is possibly linked to union law, there everyone agreed, is the value-added tax component of the case. Income tax, no. Social security contribution for the employer, no. That was agreed also for the court. It's in our judgment. But the value-added tax, there the VAT directive, and you know that the court is handing down tens and tens and tens of judgments on that directive every year, more even than it maybe likes to do, but there are many, many cases, because that is really a backbone element of the internal market, the value-added tax being a transaction tax, that there not be distortions of competition on the internal market of a fiscal nature. So you have a uniform taxable base, and as you all know, the first 1.4% of all value-added tax income of the member states is handed over as an own resource to finance the union budget. So the court said, since the value-added tax directive is providing for effective, deterrent, yet proportionate sanctions to be adopted by the member states without specifying what these sanctions should be, the court said that anything the member states do by way of sanctioning apparatus in order to enforce the correct compliance by taxpayers in the value-added tax with their obligations to correctly declare their tax liability in the value-added tax, that is the putting into effect of that general obligation to provide effective deterrent and proportionate sanctions. I mean, one can say, well, this goes very far because it's in fact a part of the criminal law process which is that way sort of drawn in. But then there are some member states which might even make the choice to only have criminal sanctions to enforce compliance by taxpayers with their value-added tax obligations. So in other words, the distinguo fiscal or criminal from the viewpoint of union law is not relevant. It's the way the member state implemented its obligation to provide for that type of sanctions. And looked at it from this way, for the court, this was, I think, a rather well-founded line of reasoning, but it also shows that the court has painstakingly motivated the steps in that reasoning and made it very clear that if you are beyond that, then the court is not claiming jurisdiction. It's set in Aukerberg-France. So I found Aukerberg-France a relatively straightforward case to make the link with substantive union law. Now, to put that in perspective, you should see to it that every year we have about 25 to 30 orders, a simple order, by which we throw out cases because national courts ask all sorts of questions on the Charter, thinking, the Charter is European Union law, hence in whatever litigation pending before them, they start putting forward questions to the Court of Justice on the Charter. And the court systematically says we don't see any substantive law link between the litigation pending in the national court and European Union law in general, and therefore we don't come to an interpretation need of the Charter. So there, Article 51, first paragraph, is not being met. If you want another example of the same, that is a case like Dereci. You know Dereci? This third state national, a Turkish man who wants, on the basis of the union citizenship of his Austrian wife and his Austrian children living in Austria, to come in, claiming his right to family life. And the Court of Justice says, but this Austrian lady and these Austrian children, they do not, other than in Rui Zambrano, have the risk of being removed from the territory of the Union at all. You may well prefer to live together in Austria, but that is not a risk that the citizenship rights will be taken away. So you see how cautious the court is. So those people will not be removed. They are protected in Austria on the basis of their Austrian citizenship. And the court says that is not a matter for the Charter, your right to family life, because in the relationship between Austria and these Austrian nationals living in Austria without ever having moved, that's totally domestic law. So what is here to protect the right to family life, the court adds, is the Austrian constitution and possibly the European Convention on Human Rights. Also express reference to Article 51.1 of the Charter to say that is not the required substantive link to union law. So you really have to balance that case law out and to look in all the fields of union law what the links are. And then I think you will get a rather balanced view. But it is right that in Åkerberg-Fransen, the court handed down its judgment the way it did, in contradiction to the standpoints of the member states and the Commission. That's the independence of the court. So we're going on here. Yeah, you're the next.
Yes, thank you. I'm Marta. I'm PhD holder, Warsaw University. Just would you comment on a phenomena which is quite fashionable nowadays? It's called this Europeanization of national laws, yes? It's the topic of the project, and a lot of articles are written nowadays about that. What's the Europeanization for you as a judge in the field of fundamental rights? You just mentioned about this division between the national laws and the EU law and how to balance that. Could you comment on that, giving some examples of the case law?
Well, it's maybe not totally that, but what your example makes me think of at first reaction is a case like test achat. Do you see what the case is about? This is this case about the equal treatment of women and men in the field of life insurance. It's a judgment of our court of March 2011. So what had happened is, in 2005, the ordinary legislative procedure on a proposal from the Commission, qualified majority in the Council, parliamentary majority in the European Parliament, a directive has been adopted in order to promote and enforce the principle of equal treatment between women and men on the internal market for services. Now, services include, of course, insurance services. Now, for some types of insurance, the length of life of the person insured is a factor of risk from the viewpoint of the insurer. And two examples rapidly show this. You have the supplementary pension insurance. That is, your whole active life you contribute a given premium to an insurance company in exchange for the benefit that, let's now say, once you're 65, every month you get a given promised benefit. The risk factor for the insurer is, if you live more than 100 years, he will have to pay a very long period, and you are, from his perspective, a bad risk. Now, women have the bad habit, I'm speaking from the insurer's point of view, I insist on it, of living very long, which is awful for insurers in that type of insurance. Men are brilliant people because they have the very good habit to die early, and that's for the insurer marvelous people, because they can pay less during their active time and they will get even a bigger benefit, because in any event they will only get it very shortly. No, I'm exaggerating a bit, but you see what I mean. Then you have the reverse, when people take out a loan, a mortgaged loan for financing their house, normally that loan will go together with an insurance that if ever you die as the debtor before the loan has been paid back fully, an insurance company will pay the remainder being due and the heirs of the deceased debtor are no longer bound. You know this type of insurance. There, of course, the matter is opposite. Since men have still the bad habit of dying more quickly than the women, and now it's bad for the insurer, because there the insurer will have to back up more for men than for women. So in order to insure a same amount, the man will have to pay more, the women less. So you see, it works out one time in favor of the man, another time in favor of the women, depending on the type of insurance. However, that directive said that the principle is that premiums and benefits should be equal, because people are born, woman or man, black, white, yellow or something else, homosexual, heterosexual, fundamental features of the personality, which simply cannot serve as the basis to even make statistics. So that is put as the principle in the initial Commission proposal. It's also a supplementary answer to your question, the principle. Then heavy lobbying of the insurance business during the legislative process, especially the insurance business active in member states which traditionally made such distinctions on actuarial statistical grounds. Not all member states had the habit to do that. Some national laws already prohibited it in Europe. So now, in the process of Parliament and Council, that is the legislative process, it gets amended. And a clause is added, the derogation clause, that in those member states, yes, only in those member states, where by the date of expiry of the transposition period of the directive, such distinctions were made between women as a group and men as a group, those member states could go on making those distinctions. The other member states, they were clicked in, they could not sort of go back in the wrong direction. Of course, big problem, equality between member states breached. Second problem, equal treatment of women and men. So, a number of consumer organizations in the member states which were authorized to benefit from that derogation, and where the law transposing the directive also transposed that derogation clause, they went to their national courts, so also in Belgium. So they brought a case in the Constitutional Court saying that now Europeanization, of developments of the law, there was a European-wide consensus, because the principle was still there in the directive of unisex premiums and benefits. And that no longer the national constitution, which also contains a clause of equal treatment between women and men, could be interpreted to the effect that the legislator is authorized to make such distinctions. So in the Belgian Constitutional Court, the law transposing the directive was challenged for incompatibility with the Belgian Constitution provision on equal treatment of women and men. And the Belgian Constitutional Court was totally inclined to accept that argument. But right before pulling over the trigger against the Belgian law, if I may say so, they said, since the Belgian law is the implementation of a clause of the directive, I'll first bring the matter before the Court of Justice and ask whether all well considered that derogation clause of the directive is not itself contrary to Article 23 of the Charter of Fundamental Rights of the European Union, another example of the Charter not vis-à-vis member states but vis-à-vis the legislator of the Union itself, and therefore unconstitutional at EU level. The reference for the preliminary ruling of the Belgian Constitutional Court was not a neutral question, I can tell you. It was a real réquisitoire, as they say in French. It was sort of a real act of incrimination against that derogation clause of the directive, and why it was absolutely contrary to the equal treatment between women and men as it should be understood anno 2010 when the reference was made. All the member states, again your questions, which wanted to make observations, about 15 of them, they came in the debate. The Commission came in. The Parliament and the Council, because it was their act. And after this long debate, the court in Grand Chamber deliberated and decided that the provision was invalid. So crossed out. The principle of unisex premiums and benefits is holding true for the whole of Europe. Europeanization of the basic values and concepts impacting on life insurance law, a private law matter, I think that is very important. It's normal that the European Union was dealing with it, because of course life insurance is now all the internal market. None of these contracts are still strictly national. All these insurance groups are pan-European, etc., etc. But that is the way it operates. And it shows that a national constitutional court like the Belgian Constitutional Court, I said that also in Karlsruhe last Monday, setting the stage for our court when submitting a preliminary reference request, it has a heavy input in the outcome of the process. Without this strong, quote-unquote, incrimination by the Belgian Constitutional Court against that provision of the directive, the outcome of the debate might have been different. So that's really the dialogue aspect which should never be lost sight of. I think
Thank you very much.
Thank you. My name is Simone Gabbi. I'm a legal officer with an union agency, the European Food Safety Authority. First of all, I join my colleagues in thanking you for this lecture. My question relates to the point in which you highlighted the importance of the broader context, and in particular international public law. If I'm not mistaken, you highlighted also the fact that usually public law, international public law, will be considered insofar as it's basically does not go contra legem and binds the European Union. My question is, to which extent can international public law, binding only the member states, be considered as an important factor in actually the interpretation of union law? And here I'm referring to a couple of rulings of the Civil Service Tribunal. I think Macchia and Schöring, the two ETF cases, in which the Civil Service Tribunal, in these cases, by the way, are under appeal before the General Court at the moment, concluded in the favor of the applicant, of the complainant, on the basis of international agreements binding member states only. Thank you very much.
Yeah. What I meant to say, more generally, I'm of course not aware of these fact settings precisely. You should because there, if I understood you rightly, it is agreements binding the member states, not the union as such. But I was, of course, first and foremost dealing with cases, and there are many of them, where the international law instrument is binding on the union. If you want an example of I think, a brilliant recent case in that respect of the Grand Chamber of the Court is the Air Transport of America Association case, ATAA, Air Transport of America Association. It is the extension to the airline sector of the emission trading system, ETS, where in order to fight against climate change, global climate change, and the emissions of carbon dioxide, the union decided to extend its emission trading system to the air transport sector. And it took as a connecting factor to the territory of the European Union that a flight is arriving in an airport of the Union or departing from it. And then it is to hand in the airline carrier the emission allowances for the whole length of such flight. So equally, when the flight is flying over territory of third states, including even the flag state of the carrier, the high seas, etc. Not only the territory of the European Union. To give an example, when the flight is taking off from San Francisco and landing in Frankfurt non-stop, the whole distance will be taken into account. And of course the Americans, they said, this is extraterritorial jurisdiction. This is against the right of overflight for the high seas and extraterritorial. The court went through all the instruments of international law to which the Union is bound and accepted that the legality of the European system be reviewed in the light of these agreements, which means that the court accepted was the Chicago Convention and also the bilateral open sky agreement between the US and the EU. The court accepted that the Union was bound by it, and especially for the bilateral open sky agreement, that it was directly applicable, directly effective, and that therefore the legality could be reviewed. Interpreting on the substance, the court found that it was compatible. But I mean, the review has been made. If it had not been compatible, the court would have quashed. That's very clear from the judgment. But it has been explained why it is meant to be or thought to be compatible. But then that same case shows up also customary international law principles. And there, the customary international law principles, the court interprets them and find also that they do not constitute an obstacle. Because, of course, these principles, I mean, the unimpeded maritime transport over the high seas is very well elaborated, also in UNCLOS, the United Nations Convention of the Law of the Seas. As far as the overflight is concerned, yeah, they were not impeded from overflying, but they were subject as a landing tax or a takeoff tax to contribute to the emission trading system whose territorial connection was landing or taking off. And the court said it's a calculation base, but which is not physically linked or impeding anything in terms of overflight. That is, in untechnical language, what the court in substance said. But what all of this shows are in fact two things. First of all, the court feels really bound to verify compliance with international law. But on the other hand, international law has contours which often are far less clear than national law, or for that matter, European Union law itself. And the European Union, standing for 28 European states, is also itself contributing to international law. So it's a subject of international law, bound by it, but it's also an active subject, not only a passive bound by it, but also an active contributing to the actual content of international law. And that should always be seen together. If you take the CADI story of which I just spoke, CADI 1, it in fact says, yes, the member states of the United Nations are bound by the resolutions of the Security Council, but not to the point that, as members of the United Nations, that they should breach their most essential guarantees of the rule of law. The court basically says that cannot have been the intention of the drafters of the Charter of the United Nations. There we signal that that is an absolute limit. That's what CADI 1 stands for. Now, if you take this whole matter of smart sanctions as an example, the so-called smart sanctions, in that the list of the persons and organizations being the target of the sanctions is included in the resolution of the United Nations Security Council, that is a phenomenon of the last 11 years. That had never happened before 9/11. There had been several Security Council sanctions resolutions, but always charging then the members of the United Nations to implement that vis-à-vis concrete persons and organizations. Which means that identifying these persons and organizations was done within the constitutional, jurisdictional, procedural framework of a given state, with all that it takes in terms of compliance with the rule of law. Now suddenly the United Nations starts making such lists of persons and organizations, not having a constitutional framework, not having a code for judicial review, not having anything, and saying, and you will apply this, eyes closed, because if you don't, you breach international law. That's what KD1 is, huh? So the European Union, 28 member states now, with a long-standing tradition as the cornerstone of the European Union in the rule of law, also member states, in order to consolidate democracy and rule of law in their own borders. Without the rule of law, the Union does not exist. I could almost say that the rule of law, with judicial review, fundamental rights review, in any context, including a context of fighting against terrorism, is about as fundamental in our code than the human dignity concern in Omega Spielhalle for the German legal order. So this is not a matter, like some authors have over quickly written, of the Court of Justice being somewhat chilly vis-à-vis international law. International law does not mean a dictatorship of a few bureaucrats or of secret services of some countries providing information to the Security Council saying do this and this, but no one can see this. No one, even not a judge. That's the place of international law.
Thank you very much.
I don't know whether I had promised go from right to left. No. You're the next one. Yes, people are waiting. Excuse me.
I want first to thank you for the nice lecture. And later on, since you brought the topic of extraterritorial jurisdiction, I want to ask you about the extraterritorial application of EU competition law. Basically how it has developed in the cases of wood pulp and dye stuffs, where the court has developed the concepts of single economic entity and the implementation doctrine. And my question concerns the recent, well, not so recent anymore, Gencor case and the stipulation that's really coming close to the effects doctrine. And I want to ask directly whether the effects doctrine exists in EU law, or we will only rely on the concepts developed by the Court of Justice?
Well, I shall indeed answer in a very short fashion. I think nothing has been changed recently in that case law. Gencor and other more recent cases, including, by the way, to some extent, the ATAA case to which I just refer, this is the contribution of Europe to the combating of climate change, is of course there is a flavor of effects doctrine in it. But what the court really says in both these competition cases and these environmental cases is that when damage is occurring on the internal market in a competition context, in that transactions are being concluded on the market whose content is affected by anti-competitive practices, then it is irrelevant whether the anti-competitive practice has been concluded by way of gentleman's agreement in a hotel in Tokyo or in Sydney. If the transactions are here affected, whose content is different, then there is effect, but at the same time there is also implementation. There is also action complying with these anti-competitive practices. And the same applies for the fight against climate change or fight against global warming. That is indeed that the court says, well, the flights, they are landing here, taking off here without the European Union territory being used, the pollution they are contributing in that full length of flight to the to the climate change, that is the contribution to the pollution, would not take place if there was not a landing or the arrival here. So that is a sufficient connecting factor. So there is action and there is effect. But of course the effect is diffuse. Global climate change is changing the climate everywhere, including the Union. And it is of course nonsensical to fight only in Europe against global climate change. So ideally, in all the jurisdictions around the world, you should do your part of the fighting against the global climate change. So I think, oops, I've fallen from there. I think from the perspective of actual, of real life, this whole distinction between effects and implementation is more and more artificial. It's still there in the books, but in fact there are always acts, at least partially, committed and affected by what has been done elsewhere. It's more an interdependent action in several territorial jurisdictions whose effects will be felt both outside and inside the Union. So it's a combination of implementation and effects. And that's really how the court proceeds ever since the wood pulp judgment. And as I said, not limited to these competition law cases, you should certainly also take a look at all these international environmental cases. And it's not only ATAA, it's also cases like Intertanko. There are a few others which are relevant in that context. I think that is the last one. Yeah.
Thank you very much, Judge Lenaerts. My question, I mean, you've talked about, in answering to some questions, you talked about this monopoly that the Court of Justice has in interpreting, as a last instance court, European Union law. One might call it the principle of autonomous interpretation as well. When it comes to the area of fundamental rights, there's a ever-developing relationship between Luxembourg and Strasbourg. Probably you agree with that. But the newest development is the ongoing accession of the European Union to the European Convention on Human Rights. And my question would be, how do you see this relationship changing if ever the European Union will actually accede to the Convention, especially in light of the Bosphorus presumption?
Yeah, I think that if the Union accedes, that is a hypothesis, to the European Convention on Human Rights, which should normally happen one day, I think then the relationship will become the normal relationship as between any contracting state to the ECHR and the Convention. That is, the European Union will then, as it should be perceived as a domestic legal order common to the 28 states, having its own primary law instruments, that is the treaties and the charter, being the written constitution in a material sense of the legal order. Our court will interpret the fundamental rights in interaction with the national constitutional courts. My Testachat example shows it. Also leaving room for the national constitutional courts, taking cognizance of their case law, inserting it also to the all extent possible in our case law. So this whole interactive process will go on inside the European Union legal order. The sole question which might then be relevant, but which is exactly identical in the relationship between the Human Rights Court and the Bundesverfassungsgericht, or the Human Rights Court and the UK Supreme Court, or the Human Rights Court and our Belgian Constitutional Court. You will have that same relation vis-à-vis the Court of Justice, that if it is felt that our court has given an interpretation of the ECHR which is not consistent with the minimal level of protection offered by Strasbourg, then there will be a case brought against the European Union or against a member state plus the European Union in the co-defendant structure. If it should be so that a case is brought of that nature on which our court has not yet interpreted or verified the legality of a rule of union law, as you know, there will be an interruption of the Strasbourg procedure in order to allow our court to pronounce. And that is quite logical, because, as you know, the Strasbourg system is a subsidiary system vis-à-vis the national systems. The equivalent of that subsidiary status vis-à-vis the European Union is that Strasbourg cannot interpret or control the legality of union law before our court on the litigious point has done so. This has nothing to see with preeminence of one court over the other. It's simply the equivalent from the perspective of the Strasbourg system, that their saying should be subsidiaire vis-à-vis our saying. And so, if for procedural reasons a national court did not make a preliminary reference, we have not yet been in a position to pronounce on the interpretation of one or another rule of union law, or control its legality, that is normally here in this context compatibility with the Charter, then Strasbourg will simply interrupt and leave us the possibility to do that. So the question is not so much who has the last word. The last word on the convention is of course the Strasbourg. That's why accession is being considered. But the question is who has the first word? And that is us. And of course, all my contacts in the Strasbourg court are rather to the effect that Strasbourg feels the risk of marginalization. Because, I say this in order to correct an impression. People think, the Court of Justice is somewhat fearful of the fact that its judgments will be reviewed by Strasbourg for their compatibility with the European Convention on Human Rights. That's frankly speaking not a problem. That happens since more than 50 years with all the national supreme and constitutional courts. And of course, we have a long tradition of using the case law of Strasbourg. And the Charter even obliges us to do that. The third paragraph of Article 52 and Article 53. So we're used to that. So normally that should not be the problem. The problem is from the Strasbourg perspective, that's the opposite problem, that if we give a content to the Charter which is more far-reaching than what they do, to conclude, because it concludes nicely, I return to my El Ghafaji case, the two Iraqis, as you remember. After that judgment, Strasbourg was, on the one hand, very happy because we had given such an exigent and far-reaching interpretation of the fundamental rights of this person. But at the same time, they have realized that letter A and letter B, as I said in my speech, are respectively Protocol 6 and Article 3 of the ECHR, but that there is in their system nothing of letter C. So in terms of marginalization, when we had our first, because every year we come together in an informal dialogue with that court, either in Strasbourg or in Luxembourg, they said it's a brilliant judgment, but frankly speaking, if that is enough in order to get this subsidiary protection under the Qualifications Directive in these 28 member states of the Union, why would they still bother about a much more difficult to establish letter A, death penalty, or this degrading punishment, which is sometimes much more difficult to establish than this third category? And it's only one example. The ne bis in idem example is another one, where it was our courts to say same facts is enough. Whereas they had always said same facts, same legal characterization, same social interest being served. As you know, in the Zolotukin against Russia case, Strasbourg adapted its case law, 2009, to our case law delivered under Article 54 of the Schengen Application Convention, starting with Gozetuk and Brugge, the 2002 case. So you see, it's more that the problem, you see, that it's not a minimum level. There our court should have no difficulty. And frankly speaking, we don't need Bosphorus anymore, because Bosphorus was in fact in a context of non-accession in order to somehow save the member states. That's basically Bosphorus, because since the Union is not a party to the ECHR, it will be the member states being liable for what the Union does. And therefore Strasbourg had said not to indispose too much the member states of the European Union in their capacity as contracting states to the ECHR. The Strasbourg court says, well, we will presume that this is systemically speaking equivalent. But that, of course, will be legal history after the accession. All right, thank you very much.
Thank you. I think we should thank you.